Hello and welcome. Today we are going to talk about FAQ on professional practice, certificate of completion and compliance. All FAQ information shared in this talk is directly sourced from the official Board of Engineers Malaysia, BEM, website. Disclaimer: this talk merely reads out the FAQ content. No responsibility is assumed by the producer for its accuracy, interpretation, or application. What is Certificate of Completion and Compliance, CCC? It replaces the Certificate of Fitness for Occupation, CFO, issued by local authorities for projects approved prior to April 2007. Due to government policy to encourage self-regulation by professionals, the Street, Drainage and Building Act, Amendment, 2007, Act A 1286, was amended to stipulate that a principal submitting person must sign a certificate called Certificate of Completion and Compliance, CCC, for him to confirm that the project for which he had obtained building plan approval from a local authority is completed and has met all statutory requirements with regards to health and safety aspects and is ready to be occupied with all essential utility services connected. The principal submitting person can only be either a professional architect or a professional engineer with practicing certificate, PEPC, depending on the type of building involved. CCC is issued to the owner and its two duplicate copies must be submitted to BEM if the PSP is a PEPC and to BAM if the PSP is a professional architect, and the local authority within 14 days of issue, together with all 21 supporting Form Gs signed by the relevant submitting person of the respective professions or engineering disciplines. How should the PSP respond when a certain LA verbally instructs him not to issue Form F until they have conducted a site inspection, even though Forms G1, G21 were all duly signed by all parties to enable him to issue Form F? So long as all documents are in order, the PSP can issue the CCC. LAs cannot impose any additional conditions. As far as the LAs are concerned, they still retain their rights under the UBBLEG for site inspection during construction. LAs can report to the respective boards on any conduct violation by the respective submitting persons. The objective of CCC on self-regulation must be maintained. Original set of plans is submitted by submitting person, SP, Engineer A, but somehow the developer managed to obtain CCC signed by another SP, Engineer B. If the building then collapses, who should be responsible? The submitting person, SP, signing the respective Form GS in support of CCC is liable. The second engineer, Engineer B, who takes over as the SP is also be deemed to have taken over the all responsibilities and liability. Contractor submits a counter-proposal which is signed by his, contractor's, own professional engineer. However, upon completion, the original SP endorsed the Form G and CCC, who should be responsible? The SP who signs the Form G is responsible. Each LA/One-Stop Center, OSC, has its own procedures for CCC submission. If all the OSCs are very familiar with the submission, there would be no problem. Please take note that CCC is different from OSC. For CCC, there are local authorities, LAs, who are doing very well as they understand the CCC process. However, it is acknowledged that there will always be new staff and problems do arise. Please inform BEM/BAM of any discrepancies for BEM/BAM to refer to KPKT to resolve the problem. Please note that BEM/BAM were not involved in the development of the OSC. This is under the jurisdiction of KPKT, who has to deal with each state in charge of their respective LAs. For a building or structure built for temporary use, then demolished or renovated for other use, is the procedure of CCC repeated for renovation? Temporary structures only need a permit from the local authority. There is no need to issue a CCC. For internal changes not affecting type of use, there is no need for CCC. Is CCC required for renovation works? Where building plan submission is required, e.g. change of building facade, then CCC is required. As an example, for replacement with new lift including lift car without changes to the building, e.g. no additional floors, then no CCC is needed. For Form F signed by architects, are there corresponding Form Gs submitted to BEM? Where the architect is the PSP, all Form Fs and Gs are submitted to the Board of Architects, BEM, including those Form Gs signed by PEPs. BEM works closely with BEM to conduct checks on the Form Gs submitted to BEM. Can the PEPC employed by ECP submit/sign the Form Gs? Yes. Under CCC, who should sign for marine/fishery projects? Marine structures and facilities falls under the scope of engineer to issue CCC. Refer to www.bem.org. My appendices A, B and C, jointly issued by BEM and BEM. Form Gs, with reference to approved plan, in for works, construction done but with variation from approved plan. Do we need to submit as-built plan to reflect the change? What is the best way to solve this? Submit as-built plan to the local authority before or when issuing CCC. Contractor has split up, who then can sign the Form Gs on behalf of the contractor for CCC certification? The moment a particular work is completed, arrange for its Form G to be signed, and keep it. Do not wait until all works are completed. However, in unforeseen situations, e.g. demise of the contractor, then furnish proof and BEM will advise on a case-by-case basis. As stipulated in the UBBL, the submitting person who submits the drawings shall certify the completion of work. May I know why it is that in the case of lift, Form G11, the PEPC must certify the completion of lift work for which the PEPC did not submit the manufacturer's design? Under Form G11, the PE must certify as the SP. Note that the PEPC, as the consultant, designs, specifies and integrates the lift services with all other systems within the building. The lift company's competent engineer/person shall sign Form G11 as the trade contractor and is not permitted to sign as the SP. For Form G18 on street lighting, or roadside lighting which are situated within the compound of a building owner, required to be submitted to the local authority for approval as street lighting even though they are not handed over to the LA. Roadside lighting is defined as street lighting where the installations are to be subsequently handed over to the LA for maintenance. As such, these street lighting plans are required to be submitted for approval by the LA. An example would be roadside lighting within a residential housing development scheme. However, roadside lighting which are installed within a property boundary, and which are not surrendered to the LA and are maintained by the property owners, are defined as compound lighting. Such compound lighting need not be submitted to the LA for approval, and Form G18 shall be signed off as not applicable by the PSP for the issuance of CCC. Examples would be roadside lighting installed within the property boundary of an institutional, standalone residential, commercial or industrial development. Such lighting installations are deemed to be certified under Form G7 on internal electrical. In exceptional cases when the road and drainage works within a property boundary are to be handed over to the LA but not the roadside lighting, e.g. for petrol stations, then approval by the LA is required and Form G18 endorsement of such roadside lighting is applicable. Does the deemed approved rule still apply for local authority or JKR/LLM for failing to reply after the submitting person has made the official request for the letter of support for a Form G, for the issuance of Form F, CCC? Yes, it is deemed approved if no reply is received by the submitting person after 14 days from the date of submission letter of the official request for the letter of support. The letter of support is then no longer necessary to be attached with the relevant Form G for the issuance of CCC. For this case, please attach a copy of your letter to the LA or JKR/LLM together with the respective Form G. Taking over another engineer's works, will the new engineer be responsible for the whole of the works even though the works are already ongoing? As far as the law is concerned, the consultant as the SP is liable for the entire project and not any portion thereof. If the consultant disagrees or does not accept liability for works already done, then he should not take up the appointment. After a project has been issued a CCC, is the LA responsible for its maintenance, i.e. for roads, drains, slopes, culverts, etc.? Can they come back after 10 years and pin the failure on the consultant saying that the consultant is responsible for life? The consultant remains liable for his design. If failure occurs, liability will be determined by the due process of law. Certain LA requires PEPC to submit to them the Form F and only upon approval by them, the CCC can be issued. How do we overcome this? CCC can only be issued by the PSP when all requirements are met, and there is no need for prior submission of Form F to LA for clearance. LA sometimes imposes new conditions to the developer before CCC can be issued, such as to resurface neighboring roads. Otherwise, the PEPC will be fined. The CCC scheme is premised upon the PSP fully complying with the building plan (BP) approval. As such, any additional requirements imposed by the LA after issuance of the BP should be separately sorted out, mutually, between the owner and the LA. Should a PEPC encounter such unresolved issues, please forward the details to BEM to take it up with KPKT for resolution. Should the PSP be responsible to check that all submitting persons in his project are bona fide and qualified to sign the relevant Form GS? Yes, it is the responsibility of the PSP to ensure the CCC, Form F or F1, issued is legally valid and cannot be challenged in the court of law. Should any of the SPs certifying the various Form Gs be found to be fraudulent, or his professional practice was under suspension or deregistered at the material time of issuance, then the Form G certified by such a person is deemed invalid. This may then render the PSP certification of Form F or F1, which is based on the validity of the supporting Form Gs, to be invalid. Can a developer insist that the submitting person, SP, pre-sign a particular Form G, any of the Form G1 to 21, for the developer's safekeeping prior to actual completion and certification of the works? No, each Form G shall only be signed upon completion and certification of the works by the submitting person, SP. Pre-signing a Form G when the work is not yet completed is unethical and violates the Code of Professional Conduct. For a project with septic tank on a single factory lot where there is no external sewerage mains connecting to a central sewerage plant, is it still necessary to sign on G15 Form, Sewerage Treatment Plan? No. Form G15 is meant for central sewerage treatment plant serving several users. Septic tank in this case is treated as part of the sewerage reticulation, and SP has to sign on G14, sewerage reticulation, only. Scenario: Planner A obtained the Master Kebenaran Marancang, Master KM for 500 acres, for a mixed development project. Consultant A, the appointed Master Infrastructure Consultant, subsequently obtained earthworks approval from the local authority and proceeded to call for tender on behalf of the developer to complete all 500 acres of earthworks under the Master KM. Upon progressive completion of each scheduled phase of the earthworks and infrastructure, Consultant A has submitted the completed as-built drawings to the developer. As the developer proceeds with the development, local Kebenaran Marancang, local KM, are submitted to obtain approval for each plot of land, ranging from 10 to 100 acres per plot. For plot A, which consists of 50 acres, the developer appointed architect B as the SO and consultant B as the local infrastructure consultant to develop double-story houses. A. Is consultant B, the appointed consultant for plot A, required to submit for earthworks approval? Yes. Plot A involves a new local KM, and a new earthworks approval is required under the Street, Drainage and Building Act, 70A, 2. Extract from the Act where the earthworks are to be commenced or carried out for the purpose of the construction of any building, street, drain, sewer, or embankment, or for the laying of any cable or pipe, or for the purpose of any other construction or work whatsoever. The plans and specifications relating to such construction or work required to be submitted under this Act or any bylaws made thereunder shall be submitted to the local authority at the same time as the plans and specifications in respect of the earthworks. B. Which consultant should sign Form G1 for Plot A for issuance of CCC? As the submitting person for the new earthworks approval, Consultant B shall sign Form G1 and shall also supervise the construction of the local infrastructure and earthworks for Plot A. Consultant B is advised to obtain from the developer a copy of the Master Earthworks approval and Consultant A's letter certifying completion of earthworks at Plot A together with the as-built drawings for his record. C. Can Consultant B, the appointed consultant for Plot A, deem that he is only appointed for the building works of Plot A, double-story houses, and refuse to sign Form G1 claiming there will only be minor adjustment of earthworks, trimming and footings to be carried out? No. Consultant B, as the appointed consultant for the building development at Plot A under a separate new local KM approval, shall be the submitting person, SP, for the earthworks which is clearly defined in the Street, Drainage and Building Act, 70A, 2, and Local Infrastructure of Plot A, and shall sign Form G1 upon completion of works at site. I am the submitting person, SP, for the earthworks of a project. The earthworks was completed 3 months ago, and upon my satisfactory inspection, I signed off Form G1. However, the principal submitting person, PSP, informs me that I should leave the date blank. I wish to check with BEM as to whether I have to insert the date when I sign any CCC Form GS. The SP or PSP, when signing off CCC forms, F1 or G, must insert the date to make it complete. This requirement is clearly stated in the guide to filling up CCC forms. Note that Form GS can only be signed off and dated when the related work is completed. Please refer to other related FAQs for more elaboration. I am the SP, PEPG, for an ECP, Consultant E, appointed as consultant for a building to be sited on a completed earthworks platform. The proposed building consists of a semi-basement and a 5-story tower. The foundation system to be adopted will be a piling system. The earthworks platform was completed many years ago, and the Form G1 was signed by a previous SP, Consultant A. As the consultant for the proposed building, am I required to take over the as-built earthworks and sign a new Form G1 after the project is completed? Yes. As your design involves excavation of a semi-basement, you shall to take over the responsibility for the earthworks from the previous SP. You are required resubmit for earthworks approval and sign off Form G1 for earthworks upon completion of the earthworks at site. Note that even if there is no semi-basement design, so long as you need to carry out changes to the existing earthworks, e.g. excavation, trimming, filling, etc., you are required to take over the earthworks responsibility. Only if the proposed changes are indeed very minor, you may apply for exemption from the local authority for the need to resubmit for earthworks approval. If resubmission of earthworks is exempted by the local authority, notify the PSP to sign off Form G1 as not applicable, and you should keep a copy of the Form G1 signed by the previous consultant as record. Does a utility building such as a substation require CCC? No, if the building is normally not occupied. Yes, if it is part of a development that requires CCC. For a housing development project involving construction of a bridge, does the bridge require a separate CCC, or can it be part of road and drain under Form G17? If the bridge is submitted together with the road and drain plan to the LA, then it forms part of road and drain works under Form G17. If an owner insists that his staff supervise the construction works, what can the PEPC do? Under Bylaw 5 of UBBL, it is the duty of the SP who designs the works to supervise or to delegate someone to supervise under his care. The SP still carries the responsibility and accountability. Where an owner insists on using his staff to supervise, the SP needs to verify that the staff is a BEM registered IOW and shall report to the SP to fulfill the requirements of Bylaw 5. For a building completed halfway when a second SP takes over, will the second SP be responsible for the construction works completed before his takeover, such as foundation works? The second SP who takes over a half-completed building from another SP shall be fully responsible for any work previously completed. Refer to Clause 2.2.2 of BEM Circular 001, 2016. The Water Department had approved plans submitted for a housing project. However, when the works are completed, water is not yet available. Can the SP sign Form G13 for external water supply? Such a scenario is not uncommon. If the SP has obtained approval from the Water Authority for water supply during the planning stage and subsequent building plan stage, but on completion, water supply is still not available, then it is deemed water is still not readily available for connection. However, if the Water Authority agrees to provide temporary water supply, then the SP may sign off Form G13 for external water supply. Note that the Water Authority includes any water supply concessionaire. Is rain harvesting system part of the building works, Form G12, or internal cold water plumbing, Form G5, especially if it is a simple tank collection system from a downpipe for garage use without plumbing? No. Rain harvesting system is not part of Form G5. Yes, rain harvesting system is part of the building works, Form G12. Is lightning arrestor part of the internal electrical system, G7? Yes. The LA imposes a condition to expand an existing road outside an apartment scheme for KM approval. However, when all the works are completed, the short length of road upgrading cannot be carried out because the LA is not able to get TNB to relocate the street lights. What can be done in order not to hold up the issuance of CCC and thus VP? There are a few cases where the LA impose conditions on improvement of infrastructure work outside the boundary of development area, such as widening the road and line the earth storm water channel. Under such circumstances, the SP should advise the client/developer to request that the LA to instead impose ISF, Improvement Service Fund, as provided under the Street, Drainage and Building Act, Act 133, so as to avoid the issue as mentioned above. However, if ISF was not imposed, and all other works are completed but the site of the infra improvement still cannot be handed over to the developer to work on, i.e. through no fault of the developer, then the developer should appeal to the LA to pay a sum for the construction works in lieu, in order not to hold up the approval of R&D for the purpose of Form G17, R&D, submission. Certain local authorities, LA, impose condition that before CCC can be issued, it has to be approved by OSC first. With this CCC online submission policy, do we still need to get their clearance? No. Please be reminded that even with the manual CCC submission process, there is no requirement for pre-OSC approval before issuance of CCC. Furthermore, this online system will automatically generate the CCC when all inputs are keyed in by the PSP. Certain LAs require house extension to be issued with CCC. Can it be done through this online submission system? Yes. What happens if a SP's registration has not been renewed and because of that, the PSP cannot log into the system although that SP had previously signed the Form G1 when he was still a valid PEPC? It is advisable that the PEPC should maintain his registration until all obligations to sign Form GS are done. Any other similar cases may need to be handled on a case-by-case basis. The PSP will need to contact BEM for assistance. If a SP does not have an ECP and the PSP cannot key in such info, what should the PSP do? The REA stipulates that a SP can only provide professional engineering services under an ECP. The PSP cannot deploy this SP for his project if he is not registered as an ECP, and he has to either change the SP or ask the SP to be registered as an ECP provided he can wait. Are the LAs aware of BEM's online submission system for CCC? BEM has held a few rounds of discussion with JKT/KPKT on BEM's online submission system. JKT is fully aware on the implementation date of this online submission system. Note that JKT is the channel to inform all LAs. This online submission system was also reported to MOSTI under their Emerging Technology Cluster as part of the National Digital Economy Master Plan. With regards to the requirement for submitting carbon copy each to BEM and LA within 14 after issuance of CCC, does this still apply for the online submission system? Yes. A downloaded and printed hard copy, original, is to be submitted to the owner and a copy forwarded to the LA within 14 days. However, there is no necessity to forward a copy to BEM since this document is already in the BEM online system. For the deeming clause of 14 days for R&D or lift inspection approval, has this being incorporated into this online submission system or do we need to submit it manually? The relevant documents must still be manually uploaded on the online system as evidence. No submission of hard copies to any authority is required. For a project that a PEPC designs on pro bono basis, such as an open steel shed for a temple or mosque, can CCC be manually issued as the PEPC does not have an ECP and is not doing business? If the PEPC is practicing under an ECP, then he should submit through the online system. However, if the PEPC is not practicing under an ECP, then he may submit manually by consulting BEM to reactivate the phased-out manual system for the particular case. I understand that OSC 3.0 Plus recently introduced by KPKT listed Process 6 involving the issuance of CCC as an online system. Is there any correlation between the KPKT system and BEMs? BEM has had detailed discussions with JKT/KPKT. Under the OSC 3.0 Plus, CCC is at Process 6. The development process will still go through the OSC 3.0 Plus until Process 5. For projects for which the PEPC is PSP, the PSP can opt to use BEM online submission system, which is an independent system of submission. For an abandoned project which was recently revived, some of the Form GS were previously signed off for completed works. However, the respective SPs are no more practicing or have passed away. How would this online submission system cater for this? This will need to be dealt with on a case-to-case basis as more information is required to be verified. The PSP needs to refer to BEM with all the necessary documents and evidence. For a project outside the LA area, can this CCC online submission work? CCC online submission is designed for area under the jurisdiction of a LA. However, for areas outside the LA area and if the district officer office requests the nearest LA to assist to process the development plan, then this CCC online system shall also apply.
If you like our content, kindly like, share and subscribe.